Hi everyone, this is Mike. This is the third part in a series of podcast episodes on the Fourth Amendment. In this episode, I'm going to talk about stop and frisk. And getting right down to it, police have the authority to briefly detain people for investigative purposes, even if they lack probable cause to arrest. Now, they can't just do so arbitrarily. To make a stop, they have to have reasonable suspicion. And when we talk about reasonable suspicion, it has to be reasonable suspicion supported by articulable facts of criminal activity or involvement in a completed crime. This is a phrase that comes out of the case of Terry versus Ohio. If the police also have reasonable suspicion to believe that the person is armed and dangerous, they can actually go so far as to conduct a frisk to ensure that the person has no weapons. A frisk is a pat-down or what we would call a limited search of the person's outer clothing to ensure that the person has no weapons and that the officers are not placed in any danger or peril. Now, let's talk about this idea of reasonable suspicion. Unfortunately, the court has not specifically defined reasonable suspicion. What we do know, however, is that it requires something more than a vague suspicion, but full probable cause is not required. Whether the standard is met is judged under this totality of the circumstances standard. So here are some examples. In the case of Illinois versus Ward-Lau, decided back in 2000, the Supreme Court held that there was reasonable suspicion justifying a stop when the following factors were present. First, the suspect was standing on a corner in a high crime area. Second, he fled after noticing the presence of the police. The court did make this caveat. They said that neither factor standing alone was enough to justify a stop, but together they are sufficiently suspicious. In a second case, the police had reasonable suspicion, and therefore there was no Fourth Amendment violation when they detained the defendant at an airport while dogs sniffed his bags for drugs based on the following facts known by the officer. And I'm going to list these like in the form of a grocery list. First, the defendant paid for airline tickets in cash with small bills. Second, he traveled under a name that didn't match the name for the phone number he gave. Third, he traveled to a drug source city, Miami, and stayed there for only 48 hours while his flight time was 20 hours. Fourth, the defendant appeared nervous. And fifth, the defendant refused to check his bags. Now, the fact that these suspicious circumstances are part of a drug courier profile used by the police neither helps nor hurts the totality of the circumstances inquiry. And again, this all goes to how this is a test that evaluates the totality of the circumstances, meaning all of the facts that are present. And if all of those facts being present lead an officer to believe that there is reasonable suspicion to believe that crime is afoot, then they do in fact have the reasonable suspicion that is necessary to briefly detain a person for an investigative purpose. Let's move on to the source of suspicion. Like probable cause, reasonable suspicion does not have to arise from a police officer's personal knowledge. The suspicion can be based on a flyer, a police bulletin, or a report from an informant. And the third one here, a report from an informant, is by far one of the biggest bases for reasonable suspicion. So let's talk about an informant's tip. Typically what we have here, just to give you some background of how these situations arise. Typically, a person gets arrested on some type of offense, and the person is asked by law enforcement if they would be interested in cooperating and perhaps the situation is one where the person is a low-level drug offender and was caught purchasing drugs and is charged with possession of controlled dangerous substance. Well, the police might want to work their way up the ladder, and knowing that this person is merely a minnow, they might want to lean on this person to see if he or she can lead them to the whale, meaning the seller. Because the seller, of course, is the one that is selling and putting all of the illegal substances out there in the public, and is by far a bigger threat than the buyer. And so sometimes individuals decide to turn into informants and help the police in capturing the whale, so to speak, or the seller in the example that I just gave. Now, there are some rules here. Where the source of suspicion of criminal activity is an informant's tip, the tip has to be accompanied by sufficient indicia of reliability to make the officer's suspicion reasonable. Again, the term reasonable is coming up, and we have to be very careful not to confuse the layman's definition of reasonable with the legal definition of reasonable. Let me give you some examples so you can get a general idea of what type of tips are considered to be sufficiently reliable. In an example that comes out of the case of Alabama versus White, the police received an anonymous tip saying that a woman was carrying cocaine and predicting that she would leave a specified apartment at a specified time, get into a specified car, and drive to a specified motel. The police set up a surveillance and observed that the informant had accurately predicted the suspect's movements. In that case, the Alabama court held that it was reasonable for the police to think that the informant had inside knowledge that the suspect indeed had cocaine, and the court held that the stop was justified. So further facts that were flushed out in the case is that the police actually stopped this individual based on these observations that they made. And later on in the case, the target, the person whom they stopped, made or alleged a Fourth Amendment violation. And in a pretrial hearing, the court took testimony and determined that the tipster's tip had accurately predicted the suspect's movements, and therefore the police were justified in relying upon the tip as a basis for stopping the woman. Now compare that to another Supreme Court case. This is a case of Florida versus JL, decided back in 2000. Police received an anonymous tip that a young black man in a plaid shirt standing at a particular bus stop was carrying a gun. Police went to the location. They arrived at the bus stop. They found a young black man there wearing a plaid shirt. They searched the man and found an illegal gun. Here, the court held that there was insufficient indicia of reliability in the tip to provide reasonable suspicion. They reasoned that the fact that the informant knows a person or knew that a person was standing at a bus stop does not show knowledge of any inside information. The court further reasoned that any passerby could have observed the suspect's presence. They the court also went so far as to distinguish the tip in the White case. They said that the tip here in the case of Florida versus JL did not provide predictive information and left police with no way to test the informant's knowledge and credibility. If you remember from the White case, the anonymous tip predicted that this female would leave a specified apartment at a specified time, get into a specified car, and drive to a specified motel. And these were all observations that were later corroborated by police when they were doing their surveillance. In the case of Florida versus JL, the anonymous tip merely contained information that there was a young black man in a plaid shirt standing at a particular bus stop carrying a gun. There was no knowledge of any inside information, and there was no predictive information that was contained in that tip like the predictive information that was contained in the tip in White. And so the court held that there was no way for the police to test the informant's knowledge and credibility because the tip didn't provide any predictive information. And that was why the court in Florida versus JL slapped down the police and held that there was that the tip was not sufficiently reliable to give them reasonable suspicion to stop the lady. Now let's talk about the duration and the scope. To be valid under Terry, the stop must be relatively brief and in any event no longer than is necessary to conduct a limited investigation to verify the officer's suspicion. So here we're dealing with a time element, and the court doesn't give an exact amount of time. It doesn't say 15 minutes. It doesn't say 10 minutes. Unfortunately, it uses very vague and ambiguous terms by stating that the stop must be relatively brief. It does give us a little bit more to work with by saying that in any event, it can be no longer than is necessary to conduct a limited investigation to verify the officer's suspicion. So all of this ambiguity is the source of fertile arguments that can be made on both sides, on the side of the defense and on the side of the prosecution. And that's why these issues are so heavily litigated. Now, part and parcel of the duration and scope is that identification may be required. What do I mean by that? Well, as long as the police have the reasonable suspicion required to make a Terry stop, they may require the detained person to identify himself, and the detainee may be arrested for failing to comply with such a request. So, for example, if the police walk up to a person who they have reasonable suspicion to believe may be involved in some type of illegal conduct, they may ask him or her for identification. And this carries with it a multitude of potential sins, from the individual providing a fake identification to the individual misidentifying himself. And in those cases, that could lead to charges of hindering one's own apprehension, which in the state of New Jersey is a fourth-degree offense. What's interesting about this is that while a detainee may be arrested for failing to comply with such a requirement, in dicta in a case called Hibble versus 6th Judicial District Court, decided by the Supreme Court in 2004, the court suggested that it would recognize an exception to this rule under the Fifth Amendment right against self-incrimination if by merely giving his name the detainee may incriminate himself, but noted that such a case would be rare. And so the fear here is that an individual might be aware that there's a warrant outstanding for him or her, and that's what could lead the individual to hinder his own apprehension by providing a fake name or providing a means for identifying himself that is fake. This also comes up in cases where the person is undocumented, and the person fears that if he provides his real name and real information, that he could be deported. So there are just a number of sins that can come out of this. It's really a veritable tempest in a teapot. Development of probable cause. If during an investigatory detention the officer develops probable cause, so it starts as an investigatory stop, and later, based on the inquiries that the officer makes, the officer later develops probable cause to warrant an arrest. The officer can then proceed on that basis. And one of the things that would allow the officer to do is to conduct a full search incident to an arrest. So something that starts out very innocent could later result in a full-scale arrest by the officer developing probable cause. And by virtue of that arrest, the officer can justify any subsequent search of the individual under an exception to the warrant requirement called search incident to arrest. The harm here is that if the target or if the individual that was approached has drugs on him or her or something else illegal, then that would be admissible in evidence, notwithstanding the fact that this merely started out as a rather vanilla investigatory stop, and later escalated into an arrest, because, as I said before, the probable cause for the arrest justifies the police to make a search incident to the arrest, and anything found as a result of that arrest or as a result of that search is admissible, notwithstanding the fact that the officer didn't have a warrant. What constitutes a stop? If an officer merely approaches a person but doesn't detain her, no arrest or investigatory detention occurs. Not even reasonable suspicion is necessary in these cases. A seizure or stop only occurs if a reasonable person would believe that he's not free to leave. How about property seizures based on reasonable suspicion? The courts have held that police can briefly seize items upon reasonable suspicion that they are or contain contraband or evidence, but seizures must be limited. In the case of U.S. versus Place, decided in 1983, the court held that a 90-minute detention of luggage reasonably suspected to contain drugs was unconstitutional. So that's all for this episode. In the next, we're going to talk about automobile stops.